WNYC Studios is supported by Odoo. When you buy business software from lots of vendors, the costs add up and it gets complicated and confusing. Odoo solves this. It's a single company that sells a suite of enterprise apps that handles everything from accounting to inventory to sales. Odoo is all connected on a single platform in a simple and affordable way. You can save money without missing out on the features you need. Check out Odoo at odoo.com. That's odoo.com.
Brian Lehrer on WNYC. So Supreme Court decisions expected this month, or maybe in the very first days of July, include birthright citizenship, temporary protected status that covers so many people who are here, who came seeking safety or who are allowed to stay because of safety concerns in their countries of origin, transgender athletes, and mail-in ballots. That's a huge one in electoral terms, obviously. So to break down what to watch out for and what's at stake in these closing weeks of the Supreme Court's 2025-2026 term, we are joined once again by Aziz Huq, professor of law at the University of Chicago Law School, author of the book The Rule of Law, A Very Short Introduction, and he's got a forthcoming one expected next year called Into the Dual State. Interesting concept, the dual state. We'll try to get a little preview before we end here. But Professor Huq, always good to have you. Welcome back to WNYC.
Thank you so much for having me, Brian.
And listeners, if you have questions on any of mostly these big four that we're identifying as the big four Supreme Court cases that we'll get the results of very soon, call on in or text on in 212-433-WNYC, 212-433-9692. Because birthright citizenship has gotten so much press, I want to start with Watson versus Republican National Committee. That's the mail-in ballots case. What's at stake?
This is a case about a Mississippi statute that was enacted in 2020 in the context of the pandemic, allowing Mississippi voters to mail their ballot, have it postmarked by the day of the election, but have it received after the election, within 5 days of that, and still be counted. And the Republican National Committee and the Libertarian Party are challenging this Mississippi law, and there are kindred laws in about a dozen states, on the ground that there's a federal statute that says any ballot has to be both postmarked and received by Election Day as a consequence of a pair of statutes that Congress enacted in the 1840s and the 1870s, saying that here is what Election Day is. This is the date. And so the issue here is whether ballots that are postmarked but not received by the formal date of the election will be counted in, let's say, November or subsequent elections.
So it sounds to me like dancing on the head of a pin that the Supreme Court is going to have to do to decide whether Election Day under the law means the day that you cast a ballot or the day that the ballot is received, right?
The challengers to the law, who are the RNC and the Libertarians, say, look, in the 1840s and the 1870s, there was no difference between those two dates. And so you, the court, should read the word election law in federal law to say everything has to be into the state by whatever the day in November Congress has selected. The state, on the other hand, takes the position that, look, there was in the 1840s and 1870s no gap between the time that you handed in the ballot and the time the state received it, because nobody sent in ballots by mail.
Right.
So today we're in a different world, and in that different world, it is somewhat nonsensical to ask what the people who passed these statutes would have made of mail-in ballots, because it just wasn't on their mind. And it certainly wasn't, argues the state, one of the problems that Congress was trying to fix when it passed these 1840 and 1870 statutes.
Would whatever the Supreme Court decides apply to this year's midterm elections? And would it apply to states other than Mississippi? Because New York, to take one of really many examples, has the same thing. As long as your ballot is postmarked by Election Day, it's going to be counted.
I think it is likely that the court will invalidate the state statute, given the course of oral argument, and a ruling that comes in late June or early July would almost certainly be taken as applying in the forthcoming November elections. I think that the court has shown itself willing to make major changes to the structure of not just general elections, but also primary elections, even within weeks of the election being held. I think the important example of that from this year is the court's effective abolition of the Voting Rights Act Section 2 protections in a case that came from Louisiana, where the court opened the door to a elimination of a majority black district in Louisiana, essentially in the midst of primary season. So if the court was willing to do that in the Voting Rights Act case, I don't see much ground for thinking that they would stay or somehow suspend the Watson decision if it comes out in the challenger's favor until after 2026.
Interesting. You're a law professor, so I don't know if you want to comment on the politics of this issue, but I'm sure you've seen in the news where President Trump is trying, without evidence, to claim election fraud in the California primary, where they did have that rule that as long as your ballot was postmarked by Election Day, it would count, because, of course, that means they're not going to have the final count in close races for many days after Election Day itself. And Trump is using it to try to discredit faith in elections altogether by saying, see, there must be fraud here, because here it is many days after Election Day and they still don't have the result. We're going to have the same thing in New York coming up with the primary that we were talking about in our previous segment, where you can have it postmarked by Election Day, and it'll count if it comes in many days later. It might be after the 4th of July, perhaps, or close to it, that we know the results of the June 23rd primary in New York State. And I don't know if you've seen this from your perch there in Chicago, but the New York Times actually had an editorial today that basically said, regardless of what the Supreme Court decides, let's do away with this. You can mail in your ballot as long as it's postmarked by Election Day. Let's make received by Election Day the standard, because it won't give people like Trump an excuse to try to discredit elections.
I think that there's a couple of points to be made about that. The first is I'm not sure that if one eliminates this excuse for challenging the validity of an electoral result, that people like the president would cease to call fraud or cry fraud in the way that others will. So I'm not sure that's actually a reason. The second point that I would make is the Watson case concerns a federal statute that has the effect of ousting contrary state statutes. And so the challenger's case turns on the existence of that federal statute. However, that federal statute applies only to general elections in which there is a presidential or a congressional race. It does not apply to primary. And so there is no reason, even if the Watson court rules in favor of the challengers, that any primary or any vote counting rule with respect to a primary would change, because the legal question at issue in Watson is confined to instances in which there is a federal, congressional, or presidential election.
Very interesting, and thank you for being specific on that. We are previewing 4 major decisions from the Supreme Court, expected any day with University of Chicago law professor Aziz Huq. And moving on, Carolyn in Queens wants to raise another of those expected decisions, an immigration one, on temporary protected status. Carolyn, you're on WNYC. Hello.
Thank you for having me. Yeah, so we're waiting for the decision. I work with a lot of TPS communities. Everybody is, preparing for a worst case scenario, but hoping for the best. TPS, the Supreme Court specifically heard arguments whether lower courts could issue nationwide protection. That is at the core of the argument. However, many lower courts have issued protections for TPS holders while they're in litigation. And so this is a case that could really define judicial review and the authority of the executive branch or the courts for many years ahead. And so, temporary protective status has been a bipartisan has seen bipartisan support for decades, and that's why we see so many temporary protected status holders who have built lives here for decades. And it would be a grave decision on the Supreme Court to say that lower courts cannot review the executive branch and proceed to terminate protections for 1.3 million people in this country.
Carolyn, thank you for your call. And so, Professor Huq, what's the legal question here? People who have been following the news since the second Trump term began know that they've been trying to end temporary protected status for people here on that status because of things going on in their countries of origin, from Haiti, from El Salvador, from various places.
Temporary Protected Status, or TPS, is a program that Congress established in 1990 that allowed, well, initially it was the Attorney General, but now it's the Secretary of Homeland Security, to identify countries where it is unsafe for a person to return because of war, natural disease, or other temporary conditions. And if that is the case, the Secretary is supposed to consult with other elements of the government and then issue an order that has the effect of permitting certain, not all, but certain individuals who are nationals of that country to remain in the United States to work while the TPS status is in force. TPS status is always temporary. It can last 6, 12, 18 months, but generally it is automatically renewed. What's happened since the beginning of the Trump administration is that, this is largely Kristi Noem, has revoked about 13 temporary protected status designations for different countries. Probably the most numerically important of those was Venezuela. The case before the court now is a consolidation of two of the challenges to those Noem revocations concerning Haitian and Syrian TPS holders. And there are really two questions before the court. The first question is whether the courts have the power to review the Noem, not so much the substance of Noem's decision, but whether she engaged in the right procedure in accomplishing it, whether she in particular engaged in the right kind of consultation. That's one challenge, or one legal question. And that turns upon the meaning of the federal statute. And then there's a second question lurking in the background, which is, if the court can review the process whereby a designation is revoked, can it review that on the ground that the revocation was for an unlawful, an unconstitutional reason? And why that is at issue is that both Noem and President Trump made statements in relation to the TPS designation, particularly around Haitian nationals, that on any reasonable view constitute an expression of animus and hatred toward those individuals. And that's, I think, still clearly impermissible under the Equal Protection Clause. But the issue is whether the court can get that.
By the way, I think I mistakenly said El Salvador is one of those countries that they're trying to end it for. I think it is actually not, and they're at the moment keeping it for El Salvador. Nicaragua is one of those that they're trying to end it for. So do you think this is going to be a definitive ruling that's, as the caller was concerned about, going to upend the lives of hundreds of thousands or maybe millions of people, like right away?
I think the caller raised two separate and important points. The first is, what is the immediate effect of a ruling that reverses the lower courts? And the lower courts are pretty unanimously held against the Trump administration on TPS. What is the effect of a Supreme Court ruling on that would reverse the lower court on the ground, let's say, that the federal statute that eliminates jurisdiction covers this kind of challenge? If the court were to do that, the effect upon Haitian and Syrian TPS holders would be immediate and catastrophic in the way that the caller described. So I think that's a very, very fair and important immediate set of consequences to be underscored. That is indeed what happened when the court permitted, through its so-called emergency docket, the Trump administration to strip TPS status from Venezuelan nationals. The effect of that ruling was very quick.
And I gather this is another case where the Supreme Court might even give up its own authority over the President of the United States. So it's very much an executive power case, right? Because the government's central legal argument is that the relevant section of the immigration statute strips the courts of jurisdiction to review any determination that the Secretary of State or Homeland Security makes about TPS, correct?
That is correct. The way that I would think about this is that there's a whole category of cases in which the court is confronted with a challenge not to this is the wrong government decision, but this is the wrong process or motivation for a government decision. And in that second class of cases, challenges to process or to motivation, the court in the immigration space, but also in many other domains, has either relied upon statutes or created its own rules that make it very hard for challengers to bring those process or motivation claims. Here's an example. Let's say that you are prosecuted in federal court and you think that the reason for your prosecution was the president had singled you out on his enemies list. It turns out that until recently, the general approach was, well, that kind of improper motivation challenge is very, very hard to bring. And you have to bring into court really specific evidence of improper motive, even before you get to have a hearing on that question. So across the board, not just in immigration, but in criminal law, in administrative law, think about the cases in which people have been fired from various positions, including the Federal Reserve's Board of Governors. This question of when the process or the motivation behind a government decision can be challenged is actually one that is constantly being litigated, and in which the court, I think, has generally erred on the side of narrowing rather than broadening review.
Yeah. All right. Next one, the transgender athletes case, Little versus Hecox and West Virginia versus BPJ, concerning transgender athletes. It's actually two cases argued together, those two, in January of this year. And I'll note that last term, the court upheld Tennessee's ban on certain gender-affirming medical treatments for minors. In another case, now it's looking at categorical bans on transgender girls and women playing on girls and women's sports teams. Is the court working its way through transgender rights cases case by case? And if so, where does this term's expected ruling fit into that arc?
The earlier decision that you referred to, which is called Srimetti, is an unusual ruling insofar as when the court upheld the ban that Tennessee and other states have imposed upon gender-affirming care for minors, it did so on the ground that the ban was not an act that discriminated on the basis of gender. The court said, look, this is a statute that discriminates or distinguishes on the basis of age and the kind of medical treatment that you are getting. And the dissenters in that case said, I think quite persuasively, what are you talking about? You cannot apply this law unless you know the gender of the person who's receiving the care. Srimetti, therefore, avoids the problem or the question of how and when discrimination against trans individuals violates the federal constitution. So actually, Srimetti is a weird decision in the sense that it dodges what I think for many people is the central legal and moral question. I think that these cases, Little v. Hecox and BPJ, which, as you say, are about these two state laws in West Virginia and Idaho that ban transgender girls but do not ban transgender boys. Let's be clear that the statutes are asymmetrical. Ban these kids from playing upon girls' teams, right? The issue that the court's really going to focus upon is whether these prohibitions are inconsistent with a federal statute called Title IX. I think that, as in Srimetti, it is less rather than more likely that the court will turn or focus primarily on the constitutional question of whether and how discrimination against trans individuals is permissible. And I think the reason for that is that since the 1970s, Title IX, which is the statute that prohibits discrimination by federally funded educational institutions, has been understood to permit gender or sex classifications in certain contexts. So, for example, schools are permitted to have male and female bathrooms. Schools are permitted and even encouraged by federal regulation to have boys and girls sports teams. And so really the question that is at stake in these two cases, Hecox and BPJ, is we all agree that you can distinguish between kids who play on the boys' team, kids who play on the girls' team. The question is, can you use biological sex as the decision-making tool in assigning people to those teams? And I think that the force of the challenger's argument is, look, and I think this particularly is the case for BPJ, who's a minor who's now 15, but who transitioned when they were in third grade and has had both at least hormonal treatment. I'm not sure about surgical treatment. BPJ's argument is, look, if you don't let me play on the girls' team, there is no team that I can play on. I am absolutely excluded from sports in the high school context. And I think the state is counter-argument to that is, look, we are allowed to make certain kinds of generalizations when we use a decision-making tool for sorting people between teams. And even you have to admit, plaintiff, that we're allowed to have girls' teams and boys' teams. So I think that the case is going to turn into something that's somewhat narrower. I think that the court in Srimetti avoided the constitutional questions, and there's a good chance that it'll avoid the constitutional question here.
All right. Well, as we head toward the end of our time, we have taken up 3 of the 4 big decisions expected from the Supreme Court any day now. The one that we haven't talked about, and we're actually not going to because of the clock, is birthright citizenship. We've done multiple separate segments on that. So much of the media has focused on the birthright citizenship case, which, of course, is so huge and has implications for so many people here, and for that matter, yet to be born. And we will, of course, be coming back to that when the Supreme Court issues its ruling. So, Professor Huck, on your way out the door, just give us like a one-sentence preview of your forthcoming book, Into the Dual State. What do you mean by dual state?
The dual state's an idea that was developed by a German lawyer called Ernst Frankl, who's a Jewish lawyer who decided to stay in Berlin in 1933, representing people at the sharp end of the Nazi regime until 1938, when he fled. And he said, based upon his experience, look, what happens in an autocratic regime is not that the law gets completely switched off, but that the state officials seize a power to selectively switch off the law, to say, you, in this case, you don't get to benefit from the law's protection. And he articulates and describes how this worked in the 1930s in Germany. And I think it's a useful context or concept for today, because if you focus upon this idea of a switch that can be used to turn off the force of law, it helps us think about a lot of the things that the Trump administration has done since January of 2025. That's the 2-minute version.
All right, come back for the half-hour version when the book comes out, and maybe you'll be on multiple times before that as well, since it's not due out till next year. So University of Chicago Law Professor Aziz Huq, we always appreciate when you come on with us. Thanks for the preview of what to expect from the Supreme Court in the coming days.
Thank you so much for having me, Brian.
WNYC Studios is supported by AT&T. Summer. It's when we share more time, more memories, and more photos. And at AT&T, the iPhone 17 Pro is your summer essential. Its center stage front camera auto-adjusts the frame to fit everyone into group selfies. Right now at AT&T, ask how you can get iPhone 17 Pro on them with eligible trade-in. Requires eligible plan. Terms and restrictions apply, subject to change. Visit att.com/iPhone or visit an AT&T store for details.